The Kansas City outlawing of jaywalking in 1911 was a turning point in history, as it took ownership of the street away from pedestrians and gave it to automobiles. Coupled with the public shaming of jaywalkers perpetuated by the automobile industry, jaywalking laws are still used nationwide today. Despite all this, many cities across the country have abolished these laws. Streets, for the vast majority of their existence, have been a place of the people. Cobblestone roads that were perfect for walking through the city, or dirt roads designed for wagons to plod on. For the most part, streets were narrow, meandering, and unpaved. Streets were not just a way to get from one place to another. Instead, they were a jam-packed destination in and of themselves. Children played in the street, impromptu markets sprung up on every road and avenue, until the invention of the car. Prior to the car, the most dangerous thing to encounter on the street was a carriage, which were slow and easily avoided the majority of the time. The car was neither of those things. Though in their inception they were slow and easily dodged, only going as fast as 4 miles an hour in the 1800s, the cars became better and faster with time. This also meant they became more dangerous, especially because cars were relatively new technology that many people didn't understand how to use properly. In 1908, the release of the Ford Model T came to pass, a car that could go up to 45 miles an hour. With this, the issue of cars being dangerous manifested. The Model T was cheap and made readily available to the public at large scale, exacerbating the issue. In Kansas City, Missouri in 1905, Jay was an offensive word to describe backwoods people, similar to the term hick today. In those days, however, it wasn't the walkers it referred to. Jay drivers was the term for an inexperienced driver who drove in an unsafe manner, either quickly or on the wrong side of the road. In the time following the spread of the car, these drivers caused major issues that only became more and more problematic as the technology became much more powerful. In 1911, the term jaywalking was coined. Although it was originally used by pedestrians to describe fellow pedestrians, the auto industry quickly claimed the term for themselves. Special interest groups launched smear campaigns focused on the foolishness of these jaywalkers. Posters painted jaywalkers as suicidal and moronic. The National Automobile Chamber of Commerce offered newspapers free articles and statistics about the dangers of jaywalking. The American Automobile Association offered schools complimentary courses that taught students how to properly cross the street. The term grew in popularity after that. In 1911, jaywalking was a term unique to Kansas. Just a year later, it had spread to the entire Midwest. But it was in 1911 that the first jaywalking laws were passed in Kansas City, Kansas. Kansas City Ordinance Number 9846 declared, "Pedestrians crossing any street at the intersections thereof with another street within the congested district shall pass over such portion of the street as included within the lines of the sidewalk projected, and not diagonally." This meant that pedestrians were now officially restricted to crosswalks for the first time. The automobile industry had won. Jaywalking was preserved in the laws. For the first time in history, the streets didn't belong to the people walking upon them. In 1913, knowledge of jaywalking and jaywalking laws boomed outwards. It briefly became all the rage in Texas and then New York. The laws were, in some places, easily adopted. Other cities, however, proved more difficult to convert. In 1923, Cincinnati's citizens, for example, came together to sign a petition that would limit the speeds of cars in Cincinnati to 25 miles an hour, with the exception of cars that carried government personnel. Automobile industries once again engaged in a blitz smear campaign, saying that travelers would abandon the city and that government officials would abuse this law. Because of this, the petition fell out of favor with the public. In Detroit, Michigan, there were even mock trials conducted in which a student accused of jaywalking would be publicly ridiculed by hundreds of their peers. In one case, a boy accused of jaywalking was sentenced to a week of blackboard washing and was jeered at by over 1,000 fellow students.
This was the final resistance pedestrians would give for nearly another century, and although the pedestrians had resigned themselves to the new order, jaywalking laws were still a hotly contested issue in the press. "It seems to me to be very unjust," accounts from the Owensboro Messenger in Kentucky say. "I regard it as the most foolish law ever enforced. The hits kept coming, with the word jaywalking being added to the dictionary in 1924. The veritable final nail in the coffin was when jaywalking laws were passed in Los Angeles 1925. Not only were these laws stricter than most, but California had also been rapidly urbanizing for half a century. Los Angeles opened the floodgates for jaywalking laws to be adopted in California. The automobile industry maintained the initiative, engaging in meetings with Herbert Hoover, the Secretary of Commerce at the time. These meetings discussed creating a national baseline for traffic laws. It should come as no surprise that the model municipal traffic ordinance they came up with in 1928 was based off of the most rigid code in the country at that time, that of Los Angeles's. For reference, the strict code of Los Angeles required pedestrians to cross only at crosswalks and only at right angles, says Peter D. Norton, expert on the history of jaywalking and author of Fighting Traffic. If those rules sound familiar, it's because those are the same rules that we use today. These very rules are the same ones that originated in Kansas City. In the years following the adoption of jaywalking laws, the public took to self-correcting its behavior with a fervor. Educating the next generation about jaywalking seemed to be the newest craze. Children's books and songs gave catchy rhymes to remind kids to stay out of the roads and to look both ways before crossing the street. Mistress Mary, quite contrary, when her good friends she meets. Never talks and always walks when crossing busy streets, wrote C. M. Bartrug, author of Mother Goose Safety Rhymes in 1940. But although jaywalking was the word in everybody's mouth, there was a surprising lack of shame in being a jaywalker. While during the heyday of jaywalking fever just a few decades prior, 1915 through 1930, one could expect to be publicly ridiculed for jaywalking, people had simply stopped caring. The views were remarkably similar to the outlook today, that of jaywalking not being a serious crime. The focus had shifted from jaywalking to be a shameful criminal offense to jaywalking being a public safety issue, especially in relation to the safety of children. That attitude of safety, including seeing it as a non-serious crime, was passed down from generation to generation until it came to today. Now jaywalking laws aren't viewed as real criminal offenses. While jay was originally an offensive term, the word has long since been accepted across the country. Jaywalking laws aren't on anybody's mind when thinking of controversial laws, even though they are used every day. For example, in 2011, Raquel Nelson was walking home with her 3 children when an intoxicated driver hit and killed her 4-year-old son, AJ. While the driver got a 6-month stay in prison, Nelson was offered a retrial or a year of probation, all because she and her children were jaywalking when this drunk driver went on a rampage. It goes to show how successful the initiatives to normalize jaywalking went, that this occurred in a court of law. It also shows how antiquated these laws are. The jaywalking code today is what it was a century ago, although it has become more contentious recently. Many states and cities have recently decriminalized jaywalking due to jaywalking tickets being leveled more often at those who belong to minority groups. In the state of New York, a 2019 study shows that 90% of jaywalking tickets were issued to Black and Hispanic Americans, even though they represent 55% of the population. Denver is included in these cities, and, in an ironic twist of fate, Kansas City and Los Angeles, the 2 cities that started and popularized jaywalking laws respectively, have recently abolished those very same laws. Jaywalking has come a long way since its inception. While the roads once belonged to those who felt it under their feet, the turning point came when pro-automobile special interest groups took action to take away the right to walk on public roads. Jaywalking laws spread and became more natural seeming until today, where they are foundational parts of our views of public safety and road law. And although knowledge about the history of jaywalking is being disseminated more often today, the truth behind these laws is still muddled. The passing of the Kansas City ordinance that outlawed jaywalking in 1912 was a turning point that led to the foundational traffic laws that are used countrywide today.